I have the pleasure of introducing our speakers today. Our speakers are Amy Luck and Bill Beach from RCO Law. Amy is a partner at RCO and received her law degree from the University of Iowa College of Law. Her practice includes labor and employment law, civil litigation, and commercial litigation. Amy's labor and employment work includes revising employee handbooks, analyzing structural changes in a business, conducting internal audits and investigations, serving as outside counsel or legal support to human resource departments, and advising clients regarding wage, hour, and benefits questions. She also defends employers against EEOC and state entity claims, negotiates severance agreements, and assists clients through the discovery process and trial. We also have Bill. Bill is a partner at RCO and received his law degree from the University of Toledo College of Law. He has been with RCO since 1988 and focuses his practice on employment law and civil litigation. Bill serves clients ranging from Fortune 500 manufacturing companies to local businesses and nonprofit entities. He defends employer interests before various administration agencies, which have oversight authority over employment issues, including the Department of Labor, the Equal Employment Opportunity Commission, and the Ohio Civil Rights Commission. Bill's trial experience provides significant insight for the benefit of employers seeking day-to-day employment advice and defending against administrative claims. So thank you both, Bill and Amy, for being with us. I can see you, Amy. Can you see us? Awesome.
I can.
Okay.
Thank you so much. Yes, thanks for checking. And I did threaten to pan the video over to Bill. He's right here.
Very good. Well, thank you both for joining us. I will pass it over to you. I know you were coming in as we were getting started. So if you didn't hear, Milva will be watching the Q&A. And we do have time at the end for questions, but if she sees questions along the way, she'll pop in and ask those, but we are reserving time at the end for those questions as well. So thank you for being with us, and we'll pass it over to you.
Thank you so much. Thank you for that very nice introduction. And Milva, do feel free to interrupt. I prefer to be interrupted, especially if it's a question about a specific slide before we kind of forget where we were. Please feel free to interrupt because I think that helps engage everybody, especially since we're on Zoom today. Okay, I'm going to try to share my screen. Are you able to allow me to share the screen, Milva?
Yes.
It says it's disabled. Okay.
Okay, let me do that. I believe you should be able to do that now.
Got it. This one. There. Milva, can you see our slideshow?
Yes, it looks very well to me.
Okay, thank you so much. Okay, so I'm going to start today's presentation and cover several topics on the schedule today, including remote work and some of those issues, either dealing with COVID or just the new ones we've been seeing creep up quite a bit lately, especially regarding disability, FMLA claims, and some other related claims. So let's get started. Okay, so a lot of employer clients of ours are looking at whether they would like to implement a more continuous remote work policy. We all learned that if we could find a way to work remotely during COVID, we would find a way. And so there are a lot of employees who enjoyed being able to work from home, saw that there were lots of benefits, and a lot of employers saw that there could be a lot of benefits too, to allowing employees to have more flexibility and allowing employees to get their work done, and they realized they could trust them to do it, and that their employees were happier for it. So I would just encourage folks to think about what kind of remote work policy works for your particular office or work setting. Some has to be done in person. You can't greet people at the door if you're working remotely, at least not yet. And so you want to think about whether the right kind of policy involves a day or two a week for each person, for example, to work remotely, whether that's a scheduled day each week or whether that is that's fluid and it moves around. You want to think about if the policy that fits you best is just allowing people to work from home just when they need to. We have a lot of, as attorneys, we are able to work from home if the plumber is coming and you want to work from home that day so that you can be home during that 7-hour window that they give you. Sometimes you can get a lot done if you work from home, and then you don't have to stop what you're doing, drive into work, come home in the middle of the day, and then try to go back. And so you can be more efficient that way. And the kind of remote work option that just allows you to use it when you need it may work best for your office. And there are some offices where most or all of the employees can work remotely, except for certain team meetings or certain trips or certain projects that require kind of all hands on deck and in-person work. So think about the type of work you do, because every office and work setting is different, and see what you think would suit you best. Here are some of the considerations you really need to think about when you establish a remote work policy. What are the job duties of the individuals you're considering could be working from home? Are they the kind of duties that require that in-person interaction with folks? Or can you do a lot of the work on a computer or sitting at a desk when you don't have to interact with people in person? One interesting thing to think about is, what are the work habits of that person? Is that person a good independent worker? Is that person somebody you have a longstanding relationship that you can trust? Or do you need to establish a little bit more work history with that person to know? Now, when you think about work habits, you also need to think about not sort of playing favorites with folks that have worked for a long time versus new employees if they are doing the same job. So if they have the same job duties, but you're only going to offer remote work to one of them, can you justify that? So those first two kind of have an interplay that you want to be careful about, so you don't get yourself in trouble by looking like you're playing favorites or inviting a possible discrimination claim because of different decisions that you're making that may favor one type of employee over another. Another consideration, of course, is that on-site coverage. Do you need somebody to be able to greet people when they come in? Do you at least need to be able to cover between all of the employees that are remote working to make sure that schedule is one that facilitates you being able to have the appropriate amount of coverage at the office or at the work setting? Another consideration that's very important is confidentiality. Do you work with documents that include customer lists or vendor lists or donor lists maybe that you need to keep confidential? And can you create an agreement with your remote worker to make sure that they keep those files safe and secure? What kind of computer system are you going to have set up to make sure that that it has an automatic security system built in? And the last thing on this page that you need to consider is, do you require advance notice for folks who want to remote work that day, or do you require advanced approval? And note the difference. What if someone can text you in the morning at 8 o'clock and say, I'm remote working today? Is that your policy? Is that sufficient? Or do you need to know ahead of time, and do you need, and how far in advance? Or do you need someone on the other side to approve it before they're allowed to remote work? So if you're not clear about that from the beginning, oftentimes people will assume that you can just be put on notice that you are going to work remotely, and that may not work for you. You may need to have a more of a plan there. Okay, so along those lines, always communicate your expectations in writing so that there aren't those misunderstandings. Think about what kind of supervision your employee is going to need and what supervision obligations an employee will have. If a supervisor wants to work from home and you trust that supervisor to do it, how are they going to supervise the folks that work for you? Do you want them to set up regular check-in times as the list entails? Are there regular meetings? Are there Teams meetings or Zoom meetings that you want to happen during the week so that everybody can stay on task? So because those kinds of meetings may happen more often or more easily in the office setting, and you need to set up a good structure for remote workers if you're going to allow those folks to work from home. Another thing is method of tracking hours. A lot of times when you work from home, you're able to track when somebody logs in, when they log off, maybe when their keyboard has been inactive for a certain period of time and it sort of automatically logs off. Those are the kinds of things our office has, and that can be helpful in tracking the activity of somebody working from home. I'm not suggesting that you go to the extent that I've read about in terms of the law school students who took the bar exam remotely. I've read articles about how they had software where they tracked the individual's eyesight to make sure they weren't looking other places while they were taking the exam. To me, that seems extreme, and you're not going to have very happy employees if they feel like they're being tracked in that manner. But logging in and logging off seems appropriate, right? Let's see. Again, the job duties and responsibilities. Think through how the job can be done remotely. You probably have proof from COVID that many or all of those job responsibilities can be done, but what problems arose and how can you fix it now? And maybe it just means we all need to come into the office at certain times, or you need to come into the office at certain times to get those in-person jobs done every once in a while. Again, you need to think about those security needs and the home office equipment needs. Do you want your employees to use their own personal computers, or do you want to supply them with a laptop that you have more control over, that you know is updated, that you know is secure, and then what login criteria do you need, and what types of features can you add to those things so that you know it's secure, you know that the network they're using is secure. And lastly, is this a temporary option that you want to reevaluate, or are you prepared to move forward and promise that this can be a permanent deal? If it's temporary, I would suggest that you set a time frame, whether it's 30 days, 60 days, or 90 days. Say that up front, say it in writing, and tell them we are going to reevaluate this in 30, 60, or 90 days, or maybe all three. And I'm going to give you feedback about how I think it went, and I want your feedback, and listen to that feedback about how you think it went. Because maybe the employee says, you know what, I didn't like working from home that much. Or maybe the employee says, I found I got a lot done, but I could use the following resources to get it even more done or to make it more efficient. Or I think if we make sure that we all have meetings on Wednesdays at this time, that would make the workflow be even more efficient. So those kinds of evaluations go both ways. And I think that's a good way to feel it out and to see how things are going to work. And to tell them up front, this is temporary and we may go back to more in the office work so that everybody has the same expectation.
Hey, Amy, could I jump in with a question?
Yes, please. Great.
So I was just looking, and we have 22 participants, which is fantastic. And I'm assuming a number of these are smaller nonprofits. And when I'm thinking about rolling out a work from home policy with a small staff, I'm sure a concern that folks have is, especially if you have individuals who need to be in the building, like to be greeting the door, there are things that have to be done in person. How would you suggest employers present that to their small staff in a way that doesn't feel like there's favoritism? Because some jobs I'm thinking will need to be done in person, and when you have a small staff, I'm sure there could be some issues with how that's received. So how would you suggest smaller employers address that with the group?
That's a really good question, because I think feelings can get maybe more easily hurt when there is only one type of worker in each of these categories. So, for example, maybe a receptionist, their job duty requires you to be in person. And until we have the robots that delivered sushi to us in this cute little Detroit restaurant last weekend, until we have those folks greeting people at the door, you really need someone to greet somebody at the door. The first place I look is your job description. If your job description is accurate, it probably tells you that certain jobs are required to be done in person. Oh, we just lost our screen share.
It'll come back.
Okay.
Bring it back.
This one. Let's try it again. Okay, can you guys see it again? Okay, good. So look at your job description. This may also be a great time to look over those job descriptions and see if they're up to date and accurate, and what types of jobs are clear that have to be done in person, and what types of jobs did we find that we could do at home? What types of jobs did we figure out how to do at home, but it didn't work well? And I think if you as an employer can lay those things out and look at something concrete as opposed to just ideas that are that you have in your head, I think employees know that they were hired for a specific job. And if their job description matches what they do, and if you're using the job description that's in writing, that they bought into, that they agreed to, I think those are the kinds of things that you look at, and you can be consistent throughout by showing them, I'm making logical decisions based on information you have, based on information you had at the time you took the job, or you helped me rewrite this job description, and you know that some of your job requires you to be in person, and that's just what your job requires. If you really want to work remotely, is there another position in this? If that's an option, you could say maybe you're a better fit for a different job, and we'll hire a new receptionist. But if you want to be the receptionist, you know that you will not have the kinds of opportunities to work from home that other folks might, who don't require that much in-person interaction. So look to what you already have on hand. Look to documents that they know exist, that they know you didn't make up, that they bought into already, and that are accurate. And if they're not accurate, make them accurate before you implement a remote work policy, if you can. Does that help, Maggie?
I think that's great. I think it comes down to what we all know, right? Communication is the way to make your employees feel seen and heard and understood. But I feel that the smaller the organization, probably the more important that is if you're going to have people starting to work from home or continue working from home. So yeah, thank you.
Yeah, thank you for asking the question or passing it along. Okay, so the rest of the list here includes tax implications. I'm not a tax expert, but I do know that there can be tax implications if somebody's working from home versus in the office, what things are requested in terms of reimbursements, things like that. We talked a little bit about security and confidentiality already. Do you need to provide maybe a file cabinet with a lock on it to your employees so they can keep that at home, so you know your documents can be kept in there? That's an easy, seems like kind of an easy fix If you're going to allow somebody to work from home, or you want them to work from home, but they'll have documents that you want to keep secure. Again, with the confidentiality, have an agreement in writing that they agree that they're going to keep documents confidential. Are they going to pack up in their office desk at home because there's traffic throughout their house otherwise, and they don't have a lock on the door? Those are the kinds of things that normally you lock up your office at night. So how can you translate that into somebody working from home? Safety is another issue. An article I read gave a really good idea to have kind of a safety checklist with your employee before they start a remote work endeavor. So is their home office, structured in a way that is safe? Do they have cores laying around, or do they, or can you go through a checklist? The Ohio Bureau for Workers' Compensation is a great place to kind of look to see what kinds of criteria you should be looking at to make sure your home office is safe. And there are also some kind of unique workers' compensation considerations. If they get hurt at home while they're working for you remotely, is that a workers' compensation claim for you? If they get work off hours, is that a workers' compensation claim? And there are some very unique kind of fact-specific questions there, but you need to consider those things. Again, I wrote trial basis, is this a temporary endeavor, or is this something that you're willing to agree that could be permanent? And say that to them in writing. Make sure that you have the same expectations. Even if they forget later that they thought it was going to be permanent, if you all sat down and had a one-page agreement about their work from home arrangement, and you said, this is a trial basis, we're gonna try this for 60 days and look back, you can look back at that document that you had them sign and date, and they'll say, oh yeah, I guess it does say that, I forgot that. Well, I really need to convince you that this is going to work, and hopefully they can. And lastly, as we've seen a little bit with COVID, and I'm seeing more and more often with folks who enjoy remote work or are more aware of disabilities that they may have that affect their work, and they would like to work remotely because of a disability, for example. Remote work can be an accommodation. That can be something that is temporary, or it can be permanent if you agree to it. And so don't rule that out as a possibility if someone asks for remote work as an accommodation. You still need to engage in that interactive process, and we'll get to those questions here in a little bit. Maybe. There we go. Okay, we're shifting now to discipline, and a lot of perhaps large employers may have a very tight, robust discipline policy. Not everybody has to have that. You want to have a discipline policy that suits your work environment. You may not have anything in writing, but if you want to have something in writing, and I would suggest you have something in writing, you just want it to fit how you're going to enforce it and fit how you work. If you do have a policy, have you looked at it recently? Are you following it? It can be really easy to forget to look at the policy every time you feel like you need to discipline somebody, and just choose the right discipline that feels right. But you do want to be consistent with following your own policy. Many HR representatives will tell you that you need to document. You need to do regular evaluations. And when it comes to discipline, it's always a good idea to document why it is you're disciplining someone. The reason for that is there are a number of reasons. Lawyers will tell you that if you haven't documented discipline, but someone has been in trouble, and then the person files a lawsuit, you won't have documented proof that the reason that you terminated them was valid, justified, and had been a longstanding problem. It also invites misunderstandings with respect to why somebody is disciplined. But two of the main purposes in documenting discipline and just disciplining in the first place is to correct that unacceptable employee behavior. It sends the right message to all of your other employees who are doing a good job, and they know that that the employees can be accountable, and it provides that predictability for employees, and everybody feels more comfortable when they know things can be predictable. Okay, so a lot of people ask, what's a typical disciplinary process? You can formulate however you want to do it. You can make it really flexible. You can make it discretionary, although if you're not consistent with your discretion, that can cause problems for you. So if you need kind of a step-by-step process, you can use something like this, where the first thing is a verbal warning. I have clients who use a verbal warning, but they document it. So it's verbal, but it's also written down. The next step could be a written warning or a reprimand. After that, you can suspend folks. Sometimes suspensions are not effective, but you can do that, or you can take other punitive action, kind of a last chance sort of thing, or you can have an actual last chance agreement. That is typical in a lot of union settings. It's sort of that final straw. This is your last chance, and it's in writing. And then finally, termination obviously is your last step in a discipline process. Okay, so let's shift again now to, first of all, if there are any questions up to this point, please interrupt again, because we like those questions. But the next topic that we can kind of switch to is what I am seeing a lot more of, which is disability discrimination. So that involves the ADA, we're all kind of familiar with that. And then there are also Ohio disability discrimination laws as well. A disability discrimination case involves proving that the individual has an impairment, or a disability includes that the person has an impairment that affects a major life activity. That definition of major life activity has expanded quite a bit recently, and that impairment is a substantial limitation on the individual's life. So to prove that the person has a disability discrimination claim, that person has to be a qualified individual under the ADA. That can be pretty fact specific, but they have to have a disability that affects their life. But they do have to be able to perform the essential functions of the job with or without an accommodation. If they just can't perform it because they have a disability, no matter what kind of accommodation could be provided, then they do not have a disability discrimination claim. But if they're requesting an accommodation and they say they can perform the job with that accommodation, then they may be successful in their claim. And then that last item of direct threat defense, that came up kind of more prominently during COVID in terms of whether someone who was unvaccinated or unwilling to wear a mask became a direct threat to others if they were in the workplace, and what kinds of decisions employers could make based on that alleged direct threat. Another example when it comes to disability is if you have someone who can't perform a certain function. For example, let's say this, their doctor says they shouldn't be on ladders, but their job is as a roofer, and they have to get on a ladder to work. But their disability affects their balance, and so they can fall off a ladder, and that's why their doctor said they shouldn't be on a ladder. So an employer can say, listen, if you get on a ladder, you're not supposed to get on a ladder, but if you do, you could fall and hurt yourself, or you could hurt someone else. And so that creates a direct threat, and therefore we can't accommodate, we can't allow you to work if your job requires you to be on a ladder. Okay, so we mentioned this earlier, that interactive process is incredibly important. It obligates both sides to engage in good faith in the interactive process. That can be as easy as asking, how can I help you? When an employee comes to you and says, I think, I have an issue. They don't have to say, I need a reasonable accommodation, but they can say, I'm having an issue with my desk, or I'm having an issue with getting up the stairs. If you start with, how can I help you? Sometimes their response is such a simple solution that it's done right there. And it's easy for you to grant whatever accommodation they need. Sometimes it's a lot more complicated, and they're asking for, something that you feel is unreasonable. But you need to take that back and forth. You can't just say no to what they're suggesting and it's the end of the conversation. You have to go back and forth until you can figure out if there is a reasonable accommodation and whether you can achieve that and whether that'll work. And so employees are not entitled to their desired accommodation. They don't get to pick it as long as you can, if you have another accommodation that will work just as effectively. But sometimes employees come up with the best types of accommodation. So you always want to listen to what they have to say. The legal standard here is undue hardship. Expense can be part of that equation. If they're asking you to build on a separate shack to their office, that could be undue hardship. But if you're only relying on the expense and not coming up with any other ideas, you may find yourself in trouble. So the undue hardship can also be, I want to work remotely even though I'm a receptionist. And that can be sort of out of line, and that's as simple as it can be in terms of demonstrating that that's an undue hardship. So in disability discrimination cases, you want to be careful about, an employee needs to prove that they had a record of impairment. Sometimes you know that the person has a disability because they've told you or because it's obvious. And they may have provided you documents that disclosed it. Those are the kinds of things in their personnel file that you can look for to see, gee, did we as the employer know that the person had a disability, and how did we handle that? They can also assert claims that are called regarded as disabled or perceived disability. Did you treat them like they had a disability even though they didn't have one, or even though they weren't asking for an accommodation, but you treated them differently because you thought they needed something different, or that you thought that they couldn't do something that in fact they could do. We're seeing, I think, unfortunately, we're going to see some COVID long hauler disability type claims. So keep the conversations going. Maggie made a great point that communication is sometimes your best first step in resolving so many of the issues that end up in cases down the road that started with a lack of communication or some wrong and communication or shut off communication. And then there are also claims called associational discrimination claims. Those come up oftentimes if you have an employee's spouse or child who maybe has a disability that the spouse needs to care for, or the employee needs to care for the spouse, or the employee needs to care for the child and needs to be away. And you treat them differently because you perceive that they will be unavailable for certain things because of that obligation. Related to that somewhat is the FMLA discrimination. Interference claims under FMLA discrimination come up when you fail to allow a valid FMLA claim to be approved. Use that Department of Labor form. Most folks do. If you're a small employer, maybe FMLA doesn't apply to you. But if you do allow FMLA or FMLA-like leave, you can use the form as your guide because it has the right criteria and it directs you to defer to the treating physician in terms of what it is that the employee needs. And you always want to make sure that what the employee is asking for matches what the employee's physician has said that the employee needs. A long time ago, I had a case where the employee said, had brought in FMLA paperwork that requested intermittent leave to go to doctor's appointments. And then she started requesting Fridays and Mondays off. And that didn't seem to match up to what her physician said she needed, unless she had doctor's appointments every Friday and Monday, and it turned out not to be the case. So because they used the form, they could follow up with the employee and say, gee, we have an obligation if we're granting you FMLA leave to make sure that what you're asking for that matches what your physician said you needed. So could you give us doctor's notes that say that you're going to appointments on the days that you request leave, or can you just verify that that's the leave that you're requesting? And that was an easy way to follow up that had been documented, and they could rely on what the physician had requested. The second type of claim under FMLA discrimination type claims are retaliation for exercising the right. So maybe you grant FMLA, but they perceive that you punish them for taking leave. So that's another area you want to be really careful of, just be consistent and follow the rules. And if they say they're available, you usually have to take that at face value unless you have contrary information. Those retaliation claims, whether it has to do with FMLA, sex discrimination, race discrimination, any kind of discrimination claims, the retaliation claims can sometimes be even stronger than the underlying claim for discrimination. For example, if someone claims they have a disability or they have a sex discrimination claim, for example, and that sex discrimination claim happens to be kind of a weak claim. Maybe you have only women in your workplace and they say they were discriminated against because they're a female. That's a pretty weak claim. But if you punish them for asserting a claim after they assert it, then you may have handed them a retaliation claim. And that's a stronger claim than their initial claim. So you want to be careful about making sure that you're not accidentally or otherwise sort of punishing folks for opposing a discriminatory practice, for participating in investigation, whether it's EEOC or an outside agency or even an internal investigation, or for requesting an accommodation, even if the accommodation seems kind of outlandish. You just need to engage in that interactive processing and try to resolve it. So themes across any kind of discrimination claim involve, are you treating people differently than others kind of in their same category? Think about the comparators. If you have two individuals that are the same job type, are you allowing one of them to remote work for no other reason than you like them better, and the other one not to remote work? Are you promoting one over the other and you haven't done evaluations in 5 years? How are you going to justify different treatment of the same similarly situated types of individuals? Now, treating a supervisor differently than their subordinate, they're not going to be comparators. So think about the same types of employees and just keep yourself in check in terms of whether you're treating them the same.
Hey, Amy, I'm going to jump in with another question.
Great.
When you're talking about treating employees differently, I'm sure that this has come up for folks on the call, but when we're returning to work, there's going to be some folks are just going to be less comfortable returning due to COVID concerns. Maybe they don't have underlying health conditions, but they have been remote for 2 years and aren't ready to return or don't feel ready to return. How would you advise employers on how to handle that? If maybe they don't have, they don't fall into a category, they don't maybe qualify for an accommodation, but they just don't feel ready or comfortable returning due to COVID concerns.
I think the answer is communication. We saw this a lot sort of earlier in the pandemic when like in the summer of 2020, I had dozens of these conversations with employers who said, we're finally calling people back and we're so excited and nobody wants to come in. And whether they were getting their unemployment checks or they just weren't comfortable. They didn't trust that that their coworkers were going to take it seriously. Are we really masking? Is everybody, they were nervous. And there are definitely a lot of people who are still feeling nervous. And so I would encourage employers to just talk to them and say, we're calling you back in the office because you are valued and we need you in person, because working in person works better for your job because of X, Y, and Z. Your job description requires it. This is, and this is where we are. These are the kinds of precautions we're taking. Now, not every office is requiring masking. It's not a state requirement anymore. And we're not doing, some of the other precautions that the social distancing, everything is a lot more lax. And for the people that are still nervous, there isn't those kinds of things that maybe you could say, but you can ask them, what makes you nervous? Are the numbers what make you nervous? Are you going to be back in your same office? You can wear a mask anytime you want. What kinds of things would make you feel comfortable in the office? Do you want to come in on the weekend and just kind of take a look around? Is there a different spot in the office you could work that's maybe a little farther away from people, but you'd still be present? Try to get as creative as you can if you really want them in there. Figure out what it is that's making them nervous. If they can't articulate what makes them nervous, then you have exhausted everything you can think of, then you sort of have to think about whether you take it to the next step, which is, well, I'm going to ask you to come in and I can't figure out what it is we can do to make everything, any safer. Did you work on the ventilation system? Is there a portable ventilation unit that you could bring in their office that would make them feel better? I mean, I don't know. There may be something like that. But if you've exhausted everything and you have determined that they have to be in the office for at least some of the time and they're refusing, then that's a choice that you can also say, I think it seems to me that you're making a choice to refuse to come to work. And we have talked through everything we can think of to make you feel more comfortable. And you haven't told me why you're uncomfortable. But I think you got to really take it, exhaust everything, because you might find that they say, oh, I'd be back in my office, or I could work in an office to myself. Oh, well, that's fine then. I'll be much more comfortable with that. And then you fixed it. And then they're coming back in. But you see what you can do to figure out what would make them more comfortable. And if their reasoning is not logical, then that's when you'll find out. But if it's logical and you can fix it, then you'll find out then too. I think that's
great. Thank you.
Mm-hmm. Okay, one of the last things I get to talk about is what happens when someone files a claim, for example, those disability discrimination claims, or FMLA type claims, and they could take it a number of different places. We've all heard of the EEOC. That's the federal agency that's in Michigan and Ohio and every other state. They could, if you're in Ohio, you may have heard or received an Ohio Civil Rights Commission complaint or charge. In Michigan, that agency is the Michigan Department of Civil Rights. They're basically the state equivalent of the EEOC, and sometimes there's work share agreements between them. And then if they've exhausted those administrative remedies, they could take their claims to federal court if there are federal claims, or state court. And that's when you probably have to contact your counsel if you haven't contacted them along the way to try to resolve some of these issues. So I think that's the end of my part of the presentation. I'm happy to take any leftover questions or any new ones. And if there aren't any questions, we'll get Bill set up. I don't know if we want to take a brief 2-minute break, or if you just want Bill to come on in, whatever you guys think.
I think a break, a 2-minute break would be nice if people need to refill their waters or coffee, quick trip to the bathroom. So we'll resume it's 9:51 now. We'll resume at 9:53.
Okay. Thank you, Vilma.
Okay, sure. Welcome, Bill. Thank you for joining us.
Good to be here.
Yes. I think we'll give everybody another minute or two to return.
That works.
And there is a question in the chat asking if the PowerPoint will be available after this session.
Yes,
Okay.
we will email them to you, or if any of the participants want to email Amy or I, we're happy to send them directly.
If you email them to me, I can send them to all the participants.
We will do that.
Perfect.
Okay.
Hi, Bill. Thanks for joining us.
Good morning.
I see you moved to the hot seat.
I did.
Very good.
So I think we can get started again.
Very good.
Most people are probably back.
Well, I'll get rolling then. We have a lot to cover. Good morning, everyone. As introduced, my name is Bill Beach. I'm one of Amy's partners here at RCO Law. And I think you will find our presentations dovetail quite well. And if there's two items that I'd ask you to consider and to remember, it is consistency in how you treat your employees and documentation. Amy and I independently use the phrase document, document, document in each of our presentations without talking to each other. So that tells you how important it is to document employment-related decisions and actions. So let's get right into it. Well, I think we're going to get right into it. Amy, any suggestions on moving this?
Click on the screen with the mouse, maybe. You need to like tell it that you're there. Just click once. There, it opens to them now.
All
There
right.
you go.
Here are the items I'm going to cover. Trending issue. Normally I would have trending issues, but we have one issue that is overriding right now in the world of employee handbooks and employment policies. So we'll address that at some length. Then I will talk about handbooks and hiring, handbooks in your day-to-day operations, and then handbooks and termination. The appendix is just going to be some information that we likely won't get to this morning, but it'll be for you to look at afterwards, because we as lawyers often talk about courts, federal courts, state courts, the NLRB, and sometimes if you don't work with those agencies or entities all the time, it gets a little confusing. So I have some maps that show what courts cover our area and what region of the NLRB that we are in. So that's just for your reference in the appendix. Again, we're unlikely to get to that, but that's what that is. Now, the trending issue has to do with the National Labor Relations Board. I hope none of you have had to deal with them before. People generally think of the NLRB as the agency that addresses union and management issues. They do that, but they also cover non-union settings. And if you hear phrases like Boeing or Stericycle, understand that these are NLRB decisions that directly address workplace policies and how employers enforce those policies. And you can see here that I've made a reference of a transition from Boeing to new work rule standards under Stericycle. And again, these are just NLRB decisions that are used for reference and that address our workplace policies. Now, the law underlying the NLRB is employees are allowed to engage in concerted activity for their mutual aid and protection. That means they are allowed to talk with one another and address issues about the workplace with one another. And they're also allowed to organize or refrain from organizing. Again, once you have the slide, I'm not going to read all of this to you, but understand you can see that this is from 29 USC section 157. It's better known as just section 7 of the National Labor Relations Act. Because it ends in the 7, it's been known as section 7 since the 1930s. But understand that even if you're not in a unionized setting, that your employees have rights to engage in concerted activities for their mutual aid and protection. Now that section of the law is enforced by, as you can see, Section 8, that it is an unfair labor practice charge for an employer to interfere with or coerce employees in the exercise of their Section 7 rights, which, if we go back one, are again concerted activities for mutual aid and protection. So you don't want to get an unfair labor practice brought against you. That's why I thought it's worthy for you to know what the law is and to have this in the PowerPoint so that you can refer to it later. Now, the trending issue is the transition that we are seeing and right in the midst of. In 2017, there was a decision called the Boeing Company. And in that decision, the NLRB laid out and tried to bring some consistency to what has been a very inconsistent application of the law to workplace policies and workplace rules. Following that decision, we as employment lawyers were happy to see that decision because, again, it tried to clarify what was a very unclear area of the law. So 6 months later, the GC, being the general counsel of the National Labor Relations Board, issued guidance on handbook rules. And that guidance followed the Boeing decision and made them clearer. So we, again, as employment lawyers, we were very happy to see the Boeing decision and to get the general counsel of the National Labor Relations Board's guidance on handbook rules. So that has been in effect through today, but things are changing. As you might remember, the significance of January 20, 2021, we got a new president. And as happens when it's a change of party, politics comes into play, and it plays both ways. It's not one or the other. But for the first time ever, a general counsel of the NLRB was fired on the very day that a new president was inaugurated. In fact, he was fired during the inauguration. 23 minutes into President Biden's inauguration, one of his staff members terminated the former general counsel. And if we go back a slide, this is the general counsel that wrote the June 6, 2018 guidance on handbook rules. So there we got a flash of light that things are going to be changing. And then a new general counsel, acting general counsel, is appointed 5 days later by President Biden. And on February 1, the old general counsel's guidance on handbooks was rescinded. So if we didn't know it come January 20 or January 25, we knew that the guidance on employee handbooks and policies was going to change significantly under the current administration. Now, the method that it is going to change is through a case called Stericycle. And you can see I have that in italics at the top of in the first paragraph. On January 6th, the NLRB issued a notice in this case, and it's titled Notice and Invitation to File Briefs. And the issue was, what should the NLRB do about the Boeing standards and a variety of workplace policies and procedures and employee handbooks? Now, all of the briefs were scheduled to be filed by March 7th, 2022 for all non-party interest groups. And I can tell you, I think only 2 employer side groups filed briefs. The rest of them were union related or affiliated groups that filed briefs seeking to change the old Boeing rules. Then the parties in the Stericycle case were to file their briefs by March 22nd. So we're just slightly over a month out from those briefs being filed. As you can see at the bottom of this page, I've got highlighted, there has been no NLRB decision yet in this Stericycle case. So what I'm telling you is that the NLRB's interpretation of workplace policies and your handbooks is likely to change significantly once this case comes out, because it was set up on January 6th to make the changes that we saw the general counsel was leading us into back on February 1 of 2021. So we do not have that decision yet. We know changes are coming. We know they're going to be significant. So I just want to put you on notice that if you hear the words Boeing, Stericycle, NLRB, pay attention over the next month, weeks. We don't know when the decision is going to come, but it is going to come. And I'm very confident it is going to change the law or the application of the law regarding employment policies and handbooks. And if you think you're confused here, don't feel alone. There's been a lot of confusion in the labor and employment world, both management, union and union side, as well as attorneys, HR folks, trying to get a grasp on an ever-changing policy and set of policies from the NLRB has been very difficult. Now, in the dissenting opinion for the January 6th NLRB decision, you can see the quote I have. It says, in its chosen role as arbiter of all workplace rules, policies, and handbooks, the board found rules violative of the act if there was any way they might be read to interfere with the exercise of the employee's Section 7 rights. Few rules could withstand the scrutiny under this test. And I fear we're going to go back to a set of standards that were pre-Boeing, and it's going to be harder for employees to write rules that can withstand the scrutiny that a policy can be, if a policy can be read anyway to be violative of an employee's Section 7 rights, then it is an unfair labor practice charge or an unfair labor practice act, and a charge could result. Now, obviously, your goal is to avoid any contact with the EEOC, the NLRB, anything that might cost you a lot of time and money. So I'm trying to make you aware that things are changing and the confusion is real. So don't feel bad if you're confused. Now, in the that prior quote was from the dissenting members of the National Labor Relations Board. The charged party, Stericycle, put in their brief to the NLRB, and this is pretty strong language, shifting the perspective from the ivory tower to the workplace floor. The board under Boeing stopped invalidating rules merely because they could be interpreted under some hypothetical scenario as potentially limiting some type of Section 7 activity. And you can see the remainder of the language on this page, but this is from the dissent again. And I have not seen language quite this strong in an NLRB opinion. So we have a 3-2 majority right now. Democrats hold the majority of 3 and Republicans the minority of 2 on the National Labor Relations Board. And as you might imagine, all the votes are 3-2 as they were under President Trump. Under President Trump, it was just flip-flop that the Republicans had the majority. And we find that all the votes are 3-2 and it's right along party lines. So this is no different than a lot of things that happen in Washington, D.C. And the only thing I want to point out on this page is what I consider to be just a great quote in the second paragraph here. You're welcome to read the rest of this. I won't go into it now. But the counsel for Stericycle, the company, called the activities of the NLRB relating to workplace rules and handbooks ideological ping pong. And I think that sums up in 3 words what we've been through since really the mid-90s, because it goes back and forth with different administrations, with different board members, and you as employers and Amy and I as employer attorneys, we are the ball and the NLRB are the paddle, because we're getting smacked back and forth over the net in different directions. So if you're a little confused on some of the issues, don't feel alone. We're going to get some more guidance, and that guidance will soon be, I'm sure, more favorable to the employees. So keep that in mind as to where we're headed. Now, the questions obviously raised in the Stericycle case is, should the standards adopted in the Boeing case be upheld? I think clearly they will not be upheld, especially since the general counsel rescinded the memo addressing the Boeing decision. And we can look forward to, like I said, much more employee-friendly activities out of the NLRB. Now, some of the more specific issues that you can see I have highlighted here is, or they relate to employer work rules. And they talk about employees being economically dependent on employers, therefore they should have more rights under Section 7, and we don't want to chill their rights. The fact that they even asked this question in their January 6th notice is a pretty good indicator that the NLRB is going to be increasing employee rights, because they feel that they are economically dependent on the employers, even though right now employees have a great variety of opportunities in the workplace because of the low unemployment rates. The second issue is, who's going to bear the burden of proof about whether a work rule is legal, lawful, or violative of the National Labor Relations Act. And then the third issue you'll see is a balancing test. How do we balance the employee's rights with the employer's legitimate business interests? I can almost guarantee you that an employer's legitimate business interest is going to be an issue that is constrained by the new Stericycle decision when it comes out, and employee rights are going to be expanded. And again, I checked right before this presentation to see if the decision had been published yet. It has not. So we're in a little bit of limbo right now. Now, some of the categories of specific work rules that are going to be addressed, I think there will be more, but confidentiality as to workplace investigations. The NLRB does not, or the majority has indicated they do not want confidentiality to apply in cases of an investigation of, say, some type of sexual harassment or gender-based discrimination. The NLRB is also going to be addressing non-disparagement rules. And this goes way beyond those two words, non-disparagement rule, because it gets into employee behavior and what an employee or a group of employees acted in a concerted manner can do in the workplace. And you will see that this is going to directly affect your insubordination policies. And then finally, one of the other specific items that the NLRB is going to be addressing is rules prohibiting outside employment. So if you have any rule prohibiting outside employment, just flag that and know that there are probably some changes come, and we'll probably need to make some adjustments to policies once we get the Stericycle decision. Other issues that are going to come into play and be changed, I think, conflict of interest policies. Employees are going to be granted greater leave to engage in behavior that might otherwise or might currently be considered a conflict of interest with the employer. Your disciplinary rules are certainly going to need some adjustment, if not just in writing, but in practice, because employees are going to be able to engage in, I would call it insubordinate behavior, going back to that non-disparagement rule that I talked about in the prior slide. Harassment policies may need to change about any confidentiality issues relating to the investigations. And the personal conduct policies, this relates to the disciplinary policies and the non-disparagement. What an employee cannot do today, they will likely be able to do after the Stericycle decision. Then, of course, we have the ever-present now social media issues about what an employee can post on social media. I think if there are limitations in your policies that say thou shalt not say anything bad about our company or any supervisor or coworker, that's probably not going to be lawful after the new Stericycle decision comes out. But stay tuned. Again, most times when I open and talk about trending issues, it's plural, But because this Stericycle decision is so significant and will impact every employer, I made it my sole trending issue for this presentation. And again, we don't have a decision. We're waiting on it. So bear with us as we wait for that decision, get a chance to evaluate it. And a couple of the other standards and tests, again, go back to burden of proof. Who has the burden of proving that a policy is lawful? I think the Stericycle decision is going to address that. And the phrase would versus could. Could a policy violate the Section 7 rights? Potentially. Or would it, on its face, violate an employee's Section 7 rights? That's an issue that's going to be addressed. And then in the NLRB's brief, or the general counsel's brief to the NLRB, and my date is wrong, I'm sorry, it should have been March 6, 2022 at the bottom. The general counsel has actually suggested that employee handbooks have a model prophylactic statement of rights for the employees in the handbooks. So I don't know if that will be required. That would be a step far beyond anywhere we've been before, but we'll just have to wait and see if the NLRB requires you to have some sort of prophylactic statement to employees in your handbook or somewhere in your policies as to the rights employees have under the National Labor Relations Act. So again, stay tuned. So these are some of the issues we're looking to have decided in the near future. All right, enough of the NLRB. Now let's talk about practical day-to-day application of your handbooks. And I use this illustration because I think people understand it. And you have to imagine that you're walking up to a castle and you are on the path. And don't start at the top, start at the bottom. As an employer, you start your defense of the castle. And if you are in the HR department or you're wearing many hats, HR being one of them, understand that you are there to defend the castle from the attacking employees. I'm certainly not saying that all employees do that, but if I were looking at each of you right now, I could see thought bubbles above your head, and you can think of the 1, 2, or group of employees that cause you 90 to 95% of your problems. So how we address defending the employer castle starts with your application and the disclaimers in your application. So make sure that in an ideal world that you're using a written application, that application has the appropriate disclaimers on the back of it. And for example, it would be an admission that yes, I am an employee at will, that there is no contract. Yes, the employer has a right to drug test me if there's reasonable suspicion that I am impaired. Things like that you want to have in your application on your disclaimers, because an employee signing up for a new job is going to sign the application. There's one line of defense that you have those disclaimers executed by the employee. This is before they even make it onto the bridge to be considered to come into your castle. If you like the employee and you make them an offer, you can include or should include language similar to that's in your application. You know, we're real happy to have you here. We think you're an excellent fit and we're going to work great together, and put in the middle of it. However, please remember that your employment is at will and there is no contract of employment, etc. Give yourself a second line before they even step in the door of defense. Have your employees sign the offer letter accepting it. And before they even walk in the door, you will have a signed application and a signed offer letter, which grants you some measure of defense in the event of a claim like Amy talked about with the EEOC, the Ohio Civil Rights Commission, the NLRB, whoever the agency or court may be. So you want to, if you remember, document, document, document. And this is part of the documentation process that relates to your handbooks, because your handbooks are going to have to be consistent with the documentation we're talking about on this page. And it's not absolutely necessary, but you can have also an at-will employment agreement. And this would be something that is agreed to before the employment starts. So you potentially could have 3 documents signed by an employee before they even make it into your castle of employment that give you some rights and some defenses. Next, there's the disciplinary warnings. That's the final door that protects you. And you do that in writing, you apply that consistently, like Amy said, and you will help yourself in the defense of any administrative or civil lawsuits. And your handbook receipt, which is a part of your handbook, it needs to contain similar language that your offer letter, your at-will employment agreement, and your application disclaimers all have. You want to make sure that your documentation is consistent so the employee knows right where they stand. So the handbook is then the castle wall that protects you, and it can set forth your rules, how you want to handle employees under different circumstances, how you discipline employees, what time they're supposed to show up, when their breaks are. It's going to be different for every place of employment, but understand that this is a system with your handbook and your hiring process, a system of setting up a defense for you as the employer in the event there are any administrative or civil lawsuit claims made against you. Now, one of the other key issues when you're hiring somebody is know whether they are an employee or an independent contractor. This is a big issue, and it's one that is really being pressed by the Biden administration and the agencies under the administration's leadership. Employees are those that receive W-2s, work for you, are an employee, have right to benefits if there are any, granted by you as the employer. And this screen was taken right off the Department of Labor's website. And it's a very, very general breakdown of the difference between an employee or independent contractor. And in fact, on January 6th of last year, I don't know if you can see this document, but it's 82 pages of 3-column small print discussion from the Department of Labor's Wage and Hour Division about what an independent contractor is and what an employee is. So if any of you would like that, I would be happy to send it to you. We could spend a full day seminar just on this subject. And there are different agencies and different laws that apply, but generally what you see on the screen applies in all circumstances. And if I had to say there's one area that distinguishes an employee versus an independent contractor is who controls the mode and the manner of how the work is done. And that's going to be critical. So when you're doing your hiring, you're doing your handbooks, know if the individual that you're dealing with is an employee or an independent contractor. And again, there is some litigation pending on this subject right now as to the application of the new rule from 2021. So as usual, and consistent with the NLRB, we're waiting for either administrative decisions or legal decisions to give us more guidance about where we are today. Again, we're involved in ideological ping pong. We are the ball, and we just have to try to stay on the table as best we can by staying up to speed on the different laws and the application of those laws. Now, getting into the practical aspects of your handbook, what's your goal? Obviously, you want to hire the best person for the job, and you want to be able to fire the person if they are not the best person for the job or just don't work out. So to proceed a termination, your defenses are built up in your hiring documents and in your employee handbook. Item number 3 here under employer goals is to create a valid basis for a just cause termination. Just cause is a phrase that is used in unemployment. You want to be able to tell the Ohio Department of Job and Family Services or the Unemployment Compensation Review Commission that you had just cause for terminating that employee. And that will help keep your rates down with the Ohio Department of Job and Family Services. If you don't have just cause and without documentation, you are very unlikely to get a just cause determination, your rates are going to be affected, and it's going to become more expensive for you to do business. Item number 4, you want to create in your handbook and in your documentation a valid basis for a voluntary abandonment argument. And voluntary abandonment goes to workers' compensation claims. Again, item number 3, just cause. That's an attempt to defend against unemployment claims even before they are made. And item number 4 is voluntary abandonment. That's an effort to defend against workers' compensation claims should one be made. Now, that is part of our entire process, the hiring from the application all the way through the handbook. We are trying to set up defenses to these type of actions. And as Amy talked about, and we'll go down to item B here, your job description for the position. You need to make sure that your job descriptions are up to date and accurate. You need to apply them consistently, because when you're inconsistent, especially with 4 people that may have the same job description, if there's somebody that's in a different demographic that gets treated differently or poorly, or thinks they are treated differently or poorly, they may have a built-in claim because they are treated different than the other 3 people who may not be in their demographic group. So again, be consistent in your application of employment rules and your handbook, and your job description is part of the document agenda that we've been talking about. Because that is, I think, the best defense to a disability claim is a good job description. Now, again, I'm going to say be consistent. I might as well say document again. In our hiring process and how that relates to your handbooks, you want to market the position, market it accurately. You're going to have your documents in a row, that being the application, offer letter, employment agreement, and handbook, as you can see here, and your handbook receipt. Now, if you change policies, say the Stericycle decision comes out and requires you to change a number of your policies, you're going to want to get a new receipt from each employee and have that receipt either signed or be able to verify that they received it and read it electronically. But the burden is going to be on you as the employer to show that they being the employee, received the handbook, received the policies, were on notice of the policy, and still violated the policy. And if you can prove that, then we go to those just cause terminations, possibly voluntary abandonment for workers' comp defense, and defenses to civil rights claims and potential litigation. So you're going to need to be consistent and have your documents applied consistently for each employee. Now, if you are a separate HR department, and I know in the nonprofit world that a lot of you wear many hats, again, think about that 1, 2, 3 or small group of employees that cause you 90% of the problem. Those are the folks that you have to write your policies to apply to, because on a day-to-day basis, they're the ones that are going to dissect your policies and figure out a way to take advantage of them. Unfortunately, it probably will harm or impair some of your good employees, but you've got to have your documents written in a way that they will take care of the bad employees when they are engaging in inappropriate behavior. Now, some of the broader day-to-day items that I like to see in a handbook are listed on this page. These are just categories, not specific policies, but they would be a category of policies. You want an introduction. You want to tell the employee, you're working with this organization. We are proud to do this for the community. And here's a little bit of our history. Make the employee feel a part of your organization and proud to work for you just through your introduction in your employee handbook. Then you want to talk about discrimination and your employment practices. In 1998, the U.S. Supreme Court issued 3 decisions that allowed employers to assert an affirmative defense to any kind of litigation in the event the employer had a written policy, followed that policy, put the employee on notice of the policy, and took prompt and effective remedial action if the employer was put on notice of a problem in the workplace. For example, sexual harassment. An employer can defeat a sexual harassment claim if an employee knows there is a policy, has alternative ways of reporting the issue. So if the supervisor is the one harassing the subordinate, the employee can go to a different person and report the harassment. And if you, the employer, take prompt and effective remedial action, you can ward off the discrimination charge of discrimination or even a lawsuit by taking that action. So you want to have those policies in place that tell employees, you know, thou shalt not discriminate, thou shalt not harass. However, if you think you are the victim of harassment or discrimination, here are your alternative methods of reporting it. And by the way, we're going to take prompt and effective remedial action if we find that there is any harassment or discrimination, and we're going to quash it. So that's what your responsibility as the employer is. And you have to have that in writing in your policies for it to be effective. Because again, no court, and I'm not aware of any administrative agency that believes any employer that says, oh, we have policies in place, we just don't have them written. Everybody knows what they are. And that will get you absolutely nowhere in an administrative claim or in a court. So you do want to have your policies. They don't have to be long, but you do have to have them in writing, put the employees on notice of it, be able to prove that the employees are on notice and have those policies. So terms and conditions of employment, that is going to change from employer to employee, or it's going to be different for everybody. How you communicate is going to be different for everybody. Workplace safety is going to be different, but those are all issues that you need to address. As you can see, we're sitting in an office. We don't have industrial machines going. So our workplace safety rules are going to be much shorter than if you were operating a factory with a lot of presses, electrical hazards, roofing hazards, whatever the case may be. So you got to make your workplace safety policies very much applicable to you directly. You also want to address time off and leaves of absence. Employees want to know, what time off do I get? What are my leaves of absence, if any? And obviously compensation and benefits, employees want to know what their compensation is going to be. Now, you don't have to put in their hourly wage or a group hourly wage in the compensation section, but you can tell them, look, you're going to be paid twice a month, or you're going to be paid every other Friday. Don't leave those items in question, and make sure that you communicate that to your employees, and the same with benefits. And with benefits, I would always say in your policies that any policies that we have are subject to the terms and conditions of our contract of insurance with our insurance provider and any applicable law, because those things tend to change, and you don't want to have to change your handbook every 6 months as a contract change, or every year as you change. So make sure that you outline your benefits, but you tell people, look, the contract of insurance rules, it prevails over this handbook, and if there's any legal or law changes, that's going to prevail over this handbook as well. Then some of you may or may not have facilities in different states or even different cities, and you might want to pay attention there and have a section in your handbook that differentiates. Say you've got a facility in Michigan and one in Ohio, you'll have one handbook that will have all the sections the same. However, you'll have the last section that says, however, for our Michigan employees, X, Y, and Z apply to you, but you only. And this section is only for those of you who work in the state of Michigan or outside the state of Ohio. So that's something to consider. Even within Ohio, if you're within the city of Toledo limits and you have a facility outside the city of Toledo, you may want to alter your policies to comply with Toledo laws, or set up a separate section to say, for those of you that work inside the city of Toledo, their municipal laws apply to you. An example of that is the Crown Act. and that has to do with hairstyles. And unfortunately, it doesn't protect people like me. It is directed at African-American women and to prevent discrimination against them specifically based on hairstyle. So that is applicable currently in the city of Toledo. The House of Representatives on a national basis passed a law earlier this year called the Crown Act, and it is working its way through Washington, D.C.'s bureaucracy. The Senate hasn't passed it, hasn't come to the president yet, but that's an example of a law that's currently in effect in Toledo. It may be in effect nationally in a year or two, who knows, but if you're in the city limits of the city of Toledo, it applies to you. Now, some of your specific core policies, not categories like we were talking about on the prior page, but your specific policies have one that addresses the at-will relationship. Reiterate, like in your handbook receipt, in your application disclaimers, and in your offer letter, reiterate in your policies that the employment relationship is at will and there is no contract. Also, you want to state somewhere in your policies that management has the unilateral right to change the policies with or without notice. And I found something that doesn't really have any legal teeth, but I found it to give deference to employers is having an introductory period. If you have a 90 or 120 day introductory period for employees, and you just realize this employee is just not going to work out, and you meet with them and give them an evaluation at the end of their introductory period and say, look, it's just not working out. You're just not the right person for this job. The administrative agencies like the Ohio Civil Rights Commission and the Equal Employment Opportunity Commission will give deference to the employer under that circumstance in many cases, that this was an introductory employee and it just wasn't working out. Therefore, there is no discrimination. And believe me, in today's world, you don't get a lot of deference from administrative agencies. So take advantage of the opportunities when you can. Obviously, every handbook should have an equal employment opportunity statement because that's one of the documents that's requested by all of the agencies, the NLRB, the EEOC, the Ohio Civil Rights Commission, Michigan Department of Civil Rights, and it will come into play in civil litigation should there be any. You want to have that policy in place. And I've already talked about the harassment and discrimination specific policy. That should be a section of your handbook, and make sure you have a complaint procedure that allows for alternative methods of reporting. Some of the other things you want to have in your handbook, again, these don't have to be long, but you want to tell the employees they don't have any expectation of privacy in the workplace, and that any ESI or electronically stored information that they have on workplace computers, phones, whatever it may be, that they don't have any expectation of privacy in that, and that you as the employer have the right to review that material at your discretion. Again, the next item, standards of conduct. This is going to be impacted by the Stericycle decision, but you want to lay down the law a little bit and tell employees what they can and cannot do, mostly cannot do. And most employers have in their standards of conduct somewhere the issue of insubordination. So that's something we're going to watch very carefully as to whether you're going to need to change how you apply that policy, or whether that could even be a written policy after the Stericycle decision comes out from the NLRB. That also applies to the discipline section that I've got listed down below. Obviously, there'll be communication and workplace safety issues. You'll want to address those as some of your core policies. Again, these are not this is core categories, and you can see there's some overlap, but these are specific policies on this page that you'll want to have in your handbook. And if you were to have nothing other than just these, you have taken steps to provide yourself a defense against administrative claims and civil lawsuits by having proper policies like are listed on this page in your handbook. Now, one of the other things that you may want to communicate to your employees in your handbook, again, contract at will. We've discussed that at some length. reiterate in your handbook that unless they have a written contract, that they're an at-will employee. But if you're going to have a non-compete agreement, a non-solicitation agreement, I suggest that those be separate documents, that you don't try to have those in the handbook, because they're not necessarily going to apply to all of your employees. They may apply to some key employees, but they're not likely to apply to all employees. So have those, in my recommendation, is outside separate documents for those employees that are appropriate for. But you do probably want to reference in your handbook that what you do at your workplace is confidential, and they are committed as an employee by this handbook to a policy of non-disclosure. And you don't necessarily have to mention trade secrets, and trade secrets aren't that big of an issue typically in the nonprofit world. But know that if you're in Ohio, under Ohio law, you have some protection under Ohio law. And you may want to reference this particular code section in your handbook so that employees know, all right, even without me signing a separate document, my employer has rights to their trade secrets under this particular law. And that can go a long way to protecting your trade secrets if you have it. Then you'll want to let the employees know what kind of category they fall into. Are they going to be exempt or non-exempt for purposes of the Fair Labor Standards Act? And basically that goes to how they are paid, as you can see, hourly or salary. Do they get overtime? If they are exempt from the terms of the Fair Labor Standards Act, they do not get overtime. However, there's a lot of litigation about, I should not have been exempt, I should have been non-exempt and received overtime. So you want to know what category each employee falls into, and you may want to explain this in your handbook or have a policy that defines what an exempt versus non-exempt employee is and how that relates to salary, hourly. And then if you have any temporary or seasonal employees, you can define their positions also within your handbook. And again, going to the independent contractor issue, we talked about that earlier. If you have independent contractors, be very careful that they are truly independent contractors. And another issue specifically for nonprofits is, do you have volunteers? Because there are some laws that prevent volunteers from doing certain things for nonprofit organizations. Volunteers are a backbone of many nonprofits, but just because you label them a volunteer does not make them a volunteer. So be very careful. Volunteers cannot engage in any money-making activities such as running a gift shop, or if you were a volunteer veterinarian clinic and you did things for animals that you charged, you can't have a volunteer engaging in that activity. And that becomes quite intricate in its analysis from a legal point. So I would tell you, as nonprofit agencies, be very careful of the issue of independent contractor and volunteers to make sure that your volunteers are not doing any business related work. Now I see that we have run out of time, but I can tell you the rest of the materials simply explain in more detail the reasons behind why we have written policies, why we need to enforce them consistently. It goes into unemployment defense, the workers' comp voluntary abandonment defense, and some of the questions and documents that are requested in this section 4 are listed by agency, what the NLRB will request from you if there is an unfair labor practice charge, what the EEOC or the Ohio Civil Rights Commission will request of you as the employer if there's a charge of discrimination. And you can see in those requests that you need to document, and a lot of it or all of it goes back to your handbook, your hiring documents, and your disciplinary documents. So we are officially out of time. Feel free to send me an email if you have any questions. And Amy, if you want to come up, we can take some questions now.
Thank you, Bill and Amy. We do have a question, and the question is how to handle a situation when a brand new employee gets a significantly higher salary than an employee that works in the same position for a few years, and due to the job dynamics has to train the new employee.
Well, we're seeing that, and we've seen that for years going on, where American-based employees are very expensive for national and global companies, and employees from China and India primarily are brought in to replace them, and the current employees are being asked to train their replacements. And I can tell you what, that is a morale killer, but I don't know that there's anything unlawful about it. Amy?
Mhm. But I think was the new employee higher paid? And the existing employee who's going to be doing the training of this newer employee is, if the new employee is getting a higher salary than the loyal existing employee, that's also a morale killer. And they have a right to communicate with each other about what they're making. The NLRB would prohibit you from prohibiting them from talking about that kind of stuff. And so you can, to the extent the employee does not bring that up at his or her annual or every 6-month evaluation, if you sense that that's an issue, you can talk to them about it, or you can reevaluate. If you have an employee who's doing the same job at the level that the new employee will be doing, then maybe you need to reevaluate what what that job is worth.
And I think one thing Amy said that's really worth highlighting is a lot of employers tell their employees not to discuss wages with each other. That is a specific violation of the National Labor Relations Act. And it goes back to that section 7 that we talked about at the start of my materials. That goes to the terms and conditions of employment. Now, you don't, as an employer, necessarily want to advertise that, oh, you guys are allowed to compare wages and notes, but you can't prevent them from doing that. If you have a policy that prevents them from doing that, we're going to want to erase that policy real quick, because that's unlawful.
Well, I don't see any other questions in the chat or the question and answer. Maggie, did you have any other questions that you wanted to bring up?
Yeah, thank you both, Amy and Bill, for being with us. I don't have any additional questions, but I did see in the chat someone had asked about something that was outside of employment. It had to do with how to take donations and things like that. I just wanted to give a quick plug. Part of the reason the Bar Association comes together with Nonprofit Connect to provide these kind of presentations is that we do have volunteer attorneys who are willing to assist nonprofits who are not able to hire an attorney with some of their non-litigation civil needs. So if what the presenters have given you today has caused you to have questions, obviously please feel free to reach out to Amy and Bill directly if you feel that they can help you with that. But if you are a nonprofit that's not in a position to hire an attorney, I would encourage you to also reach out to the TBA through our Nonprofit Connect program to help you with that. But I think the materials you gave us today, I'm sure will give people a lot to think about, and I'm sure everyone is going to be pulling out their handbooks to see if they have all of the many pieces that you discussed. So thank you very much, both of you, for your time and your expertise on this. And
I'll throw out too, Maggie, I don't want to interrupt, but if anybody is confused about the issue of overtime, volunteer, independent contractor, I do have some information sheets that I've gathered from different administrative agencies that I'd be happy to email anybody. So if anybody wants that information and you want to address or look at the volunteer issue or the independent contractor issue, I've got some fact sheets that I could send to you. So feel free to send me an email. I'd be happy to send them to you.
If we don't have any other questions or any other comments, then I believe we've concluded this webinar. Thank you so much, Amy and
Thank
Bill.
you.
This has been great information, especially very timely, and especially in telling us what's coming up, so we can be paying attention to what may change into employee law and how it's going to affect the managing of the organizations. Thank you again to the Toledo Bar Association and Maggie Humphrey. It's been great to partner with you in offering this valuable webinar. And I'd like to remind everybody that we will have a workshop in person on May 10th. That's going to be at the Toledo Bar, at the Toledo Club. And it is in regards to boards and how to make boards more effective. If you can join us, there'll be 2 sessions, one in the morning for CEOs and staff, and one in the afternoon for board members and other volunteers. And of course, you can go on our website at npr.org and get more information on our upcoming workshops and our offerings. We have a lot of information on our website too that can be useful to you, so please make sure that you visit our website. If you have any questions or anything else that you may want to bring up, but maybe you forgot and later on you remember, just feel free to email me and I'll be happy to contact Amy, Bill, or Maggie, and we'll make sure that we'll help you. So thanks again for everyone attending today. We appreciate that you've been attentive to this program, and hopefully it was very useful to you. So thank you.
Thanks, everyone.
Thank you.
Thank you.